Hello and welcome back to Prevention Connection. This week we are continuing our series on cannabis education by discussing cannabis law on the federal, state, and local level. The landscape of cannabis law is constantly evolving and legalization is shifting across the country. More people are using cannabis medically and recreationally, and laws surrounding cannabis and consumption vary. This can make things a bit confusing at times. In the United States, all cannabis and cannabis products are illegal at the federal level for any purpose, be it adult use or medicinal. Cannabis is listed as a Schedule I controlled substance, meaning it is classified as having a high potential for abuse and no accepted medical use. So, while your state laws may allow you to use cannabis for medicinal purposes, federal law does not. As a result of the conflict between federal and state law, residents in some states can find themselves using cannabis for medical purposes in compliance with state law while simultaneously violating federal law. And while laws regarding cannabis do differ from state to state, there are laws that apply across the country. Despite cannabis's illegal status federally, the majority of states in the U.S. have legalized cannabis for either medicinal and/or adult use. In 2013, the Justice Department said it would not sue to block laws legalizing cannabis at the state level if the states enact regulations. In California, cannabis is legal for both medicinal and recreational use. Recreational cannabis became legal in California in 2016 when voters approved Proposition 64, or the Adult Use of Marijuana Act. Under this law, adults over 21 years of age can use and possess cannabis for recreational purposes. However, the state left counties with the power to determine cannabis laws for their local municipalities. Proposition 64 legalizes recreational cannabis under state law and establishes certain sales and cultivation taxes. So, what is legal under California's Proposition 64? Well, here are some things. Indoor cultivation of up to 6 plants per residence, public possession of up to 1 ounce of cannabis or 8 grams of cannabis concentrates, consuming in a private residence for individuals 21 and over, buying licensed commercial cannabis in permitted counties or cities, and it legally allows cannabis retailers and/or distributors to deliver directly to consumers throughout California. Now, here is what is illegal under California's Proposition 64. Crossing state lines with cannabis or cannabis products, the possession of cannabis or cannabis products by anyone under the age of 21, sales between the hours of 10 p.m. and 6 a.m., consuming cannabis or products in any public place, consuming cannabis or products in any place that prohibits tobacco, consuming cannabis or products in state licensed dispensaries, and consuming cannabis in a vehicle or driving under the influence of cannabis. As we mentioned, California counties have the right to determine their own cannabis laws, and in Kern County, the Board of Supervisors voted to ban both medicinal and recreational sales of cannabis. That means there are no legal cannabis dispensaries in unincorporated areas of Kern County, along with the cities of Bakersfield, Shafter, Maricopa, Taft, Wasco, McFarland, Delano, Tehachapi, and Ridgecrest. Additionally, these cities also have very strict regulations regarding possession and delivery. Furthermore, the city of Arvin permits cannabis cultivation only, while California City allows all permitted cannabis activity. We know cannabis law can get confusing, and we hope we clarified some things for you today. Make sure to tune in for the next video in our cannabis series, where we will be discussing safety. Thank you so much for joining us today, and be sure to subscribe to never miss a video.